algae.
We have 7 members here, so we'll start our debate. Today we're considering several judicial nominees and 2 pieces of legislation. I'm going to spend my time talking about just one of the nominees, the 8th Circuit nominee of Jonathan Kobus. He comes highly recommended by his 2 home state senators, Senator Thune and Senator Rounds. He happens to be an Iowan as well, who at one time served as an intern in my office many years ago. Currently, Mr. Kobus serves as Senator Rounds' general counsel. The committee has also received numerous letters of support of Mr. Kobus's confirmation from the South Dakota legal community, including the South Dakota's Attorney General. Unfortunately, the American Bar Association is again politicizing a nomination to the 8th Circuit for the 2nd time in less than a year. The ABA has rated an 8th Circuit nominee, quote unquote, not qualified. Last year, the ABA rated Stephen Grutz not qualified despite the stellar record of public service in the Nebraska legal community. So what do both of these 8th Circuit nominees have in common besides their widespread support from their home states? They were both involved in abortion litigation, and both were evaluated by the same ABA 8th Circuit evaluator. This particular evaluator has a long history of liberal activism, so it's no surprise that the ABA's 2 not qualified recommendations for circuit court nominees came for nominees that she evaluated. Here are a few of the positions this evaluator has taken. She submitted a letter to the Senate Judiciary Committee opposing the confirmation of Justice Alito to the Supreme Court. And it happens that the ABA rated Justice Alito unanimously well qualified. She submitted a letter to the Obama administration and Congress opposing legal protections for religious liberty of religiously affiliated and nonprofit organizations like Little Sisters of the Poor. She has retweeted tweets mocking Justice Scalia and originalist interpretation of the Constitution. In short, as the experience with Judge Grutch and Mr. Kobus demonstrate, a Republican nominee to the 8th Circuit can't expect to get a fair shake. The ABA's admitted that, quote, Mr. Kobus is a very accomplished, competent, and capable person, end of quote, and that, further quote, does not have any question about Mr. Kobus's integrity or temperament, end of quote. According to its own explanation, the ABA relied solely on one fact to reach this determination. The ABA had, quote, difficulty analyzing Mr. Kobus's professional competence because he was unable to provide sufficient writing samples of the caliber required to satisfy committee members that he was capable of doing the work of a United States Circuit Court judge, end of quote. There's a good reason why he wasn't able to submit that kind of writing, because Mr. Kobus's legal practice for the vast majority of his career has been in-house. He has served as counsel to Senator Rounds and to several South Dakota corporations on compliance and regulatory matters. The written work product that he has developed then are not matters of public record, like briefs or court opinions happen to be, and are protected then by attorney-general or attorney-client privilege. It would be detrimental to our judiciary if we only permitted litigators, as opposed to the equally important and competent attorneys who advise clients on a range of legal issues, to join the appellate bench. Furthermore, the committee has confirmed on a bipartisan basis many nominees with very limited written work to evaluate. I see no basis then for concluding that the absence of written work product means Mr. Kobus is, quote unquote, not qualified. The most that the ABA could have said is that they didn't have enough information to come to a conclusion about his writing ability. The ABA's own evaluation found Mr. Kobus accomplished, competent, and capable, as well as having integrity and temperament. To weigh the absence of written work product over these critical characteristics that you would expect a judge to have looks like politics and not an objective evaluation. Going on now to the rest of the agenda, we also have two bills on today's agenda. First is the Deter Act, sponsored by Senator Durbin and Senator Graham. And remember, Senator Durbin has wanted us to get this sort of legislation dealing with foreigners messing in our legislative product up for a long period of time. This is our first bill, and I think the only bill. This bill combats offensive election interference by foreign adversaries by denying entry to a foreign national who's been deemed to engage in election interference. Of the many bills introduced in the Senate that attempt to address interference with the United States, as I said, this is the only one so far within the jurisdiction of this committee. We will also take up Justice for Victims of Lynching Act, sponsored by Senators Harris, Scott, Booker, Tillis, Feinstein, Blumenthal, Leahy, Durbin, Hirano, Klobuchar, Whitehouse, and Coons, and soon co-sponsored by this chairman. This bill rights a historic wrong and make lynching a federal crime. Nearly 200 anti-lynching bills were introduced in Congress during the first half of the 20th century, but none were signed into law. None signed into law. More than 4,700 people, predominantly African Americans, were lynched in the United States between the years 1882 and 1968. And most of those who committed these vile murders escaped punishment or even prosecution. Let me divert from my text, because I remember a story probably when I was in my 20s, reading about a congressman from Virginia. I think his name was Smith. And for a long time, he was a chairman of the Rules Committee in the House of Representatives, as I recall, and always bragging about all the years that he was able to keep anti-lynching legislation stored up. I don't know why anybody would be proud of that with what was going on, but it seemed to me that he wanted that to be part of his legacy. Now, since then, Congress has given federal prosecutors more tools to go after criminals who commit racially motivated violence and murder, notably the Federal Hate Crime Statute and the Riots Act. But we still don't have a statute that specifies that lynching is a federal crime. It's time that that is changed. Now to Senator Feinstein.
Mr. Chairman, I've just received a personal request for Senator Booker to say a few words. He apparently has to leave.
Senator Booker.
Mr. Chairman, thank you very much. And Mr. Chairman, I cannot tell you how grateful I am to you, sir, for helping with this anti-lynching legislation. Your staff has been remarkable, and the collegiality around this piece of legislation, bipartisan collegiality, is something that is just something I'm very grateful for and proud of. Today, we are poised for the first time in over a century of failed attempt after attempt to finally make lynching a federal crime. Sir, you mentioned the thousands and thousands of Americans who've been lynched. You mentioned rightfully that they have not only, there have never been convictions for most of them, but not even attempted prosecutions. This is a ugly, ugly part of our history. And the thing I've learned about American history is that when wrongs are covered over or wrongs are ignored, they fester like boils under the body politic, and they still hurt. A friend and hero of mine, Brian Stevenson, worked tirelessly through the Equal Justice Initiative to erect a national memorial for peace and justice, the nation's first memorial dedicated to the legacy of enslaved African Americans, people traumatized by lynchings, blacks who were humiliated by racial segregation and Jim Crow, and the people of color burdened by contemporary perceptions of guilt and violence. I really encourage all my colleagues who haven't already to go to that memorial. The stories of the lynching, firsthand accounts, the memories, the pain, the agony. It's hard to walk through there without feeling tormented and feeling the pain. This kind of reconciliation in our nation is so important to healing us, to bringing us together. The memorial is just haunting. It's a reminder of the nation's horrific past, that terrorism is not new, and unfortunately, we've seen so much terror and racialized violence committed with near impunity. This body's own past is actually stained as well, as you mentioned, Mr. Chairman, with the stigma of indifference. As Elie Wiesel once pointed out, the opposite of love is not hate, it is indifference. The unwillingness or outright opposition to addressing these crimes of our past in this body is a shameful past, but today is a proud moment. This bipartisan bill is, to me, one step towards addressing the needed reconciliation of our dark racial past. I am so grateful to Senator Tim Scott. He is an extraordinary friend, and he has really leaned into this. I'm grateful for the other members of this committee who've been leaders in this. I'm grateful for Senator Harris and her leadership. And they are really finally showing this nation that we will not tolerate bias-motivated violence in any form. And so, again, Mr. Chairman, I want to say thank you, and I hope that this bill not only will move out of committee, but will get to the floor for a vote. With my gratitude. Thank you.
Thank you, Senator Booker. And now Senator Feinstein.
Thanks very much, Mr. Chairman. Mr. Chairman, I've been a member of this committee for 26 years now, and we've reviewed thousands of judicial nominees. But what I've seen in the first 2 years of President Trump's administration should concern all of us. While I understand the President may choose nominees who have a conservative legal philosophy and who may disagree on specific issues, all nominees must have the requisite experience and qualifications to serve. And to ensure these basic standards, the Senate has relied on the American Bar Association to evaluate the professional qualifications of every federal judicial nominee since 1953. While this isn't the only factor any of us consider when deciding how we might vote, both Democrats and Republicans have relied on the ABA to ensure individuals placed on the federal bench have the necessary legal experience, impeccable judgment, ability to be impartial, and highest ethical standards. I'm concerned that these basic qualifications are not being maintained. It is true that there have been not qualified ratings in the past. However, this has been an exception and very rare. In fact, during the Obama administration, not one of his judicial nominees received a not qualified rating. However, already, in less than 2 years, 6 of President Trump's nominees have been rated not qualified by the American Bar Association. Last September, President Trump nominated Brett Talley, who had only practiced law for 3 years, never tried a case to verdict, and never argued a motion in federal court. The ABA rated him unanimously not qualified, finding that he lacked the basic experience needed to be a trial judge. Stephen Schwartz, 34 years old, nominated last year to the federal court, the Court of Federal Claims, was not licensed in and had never tried a case before the court he was nominated to. Although these nominations were not ultimately confirmed by the Senate, they were voted out by our committee and unanimously supported by my colleagues on the other side of the aisle. And Matthew Peterson, who was nominated to be a federal district court judge in D.C., also never tried a case or argued a motion in federal court. His nomination had to be withdrawn just 3 days after his hearing. Which brings us to the nomination of Jonathan Kobus to the 8th Circuit, who is up for a vote today. The ABA has rated Mr. Kobus not qualified by a substantial majority of the evaluating committee. The ABA found that Mr. Kobus does not have the, quote, requisite experience, end quote, to be a circuit court judge. Simply put, the ABA had trouble finding enough in his record to make a thorough evaluation. They found none of his writings were, quote, reflective of complex legal analysis, knowledge of the law, excuse me, or ability to write about complex matters in a clear and cogent manner, end quote. This should really be concerning to all of us. A lack of basic experience and qualifications is not or should not be a partisan issue. We should all want the best and the brightest for our federal courts, especially the circuit courts. We should all ensure that those being nominated to a lifetime appointment to the federal bench have the basic experience necessary to perform the functions of the job. So I'm disappointed that we continue to consider to vote on nominees who do not maintain these basic standards. I will vote no on Jonathan Kobus. Thank you, Mr. Chairman.
We can't go to the agenda because we don't have enough Republicans here. I thank Democrats for taking their job very seriously.
I want to speak at some point.
Can we? Could we do the bills while we're waiting to do the nominees, if it's okay with you?
And then at some point, I'd like to be recognized, John. At some point.
Well, why don't you do that right now then?
Sure.
Yeah. And then I'll call on you when we have the bill up. Is that okay?
You know, I just I was struck by what the senior senator from California just said, and I agree with her. I think we seem to have a partisan rush to discard this committee's precedents to confirm, and by discarding our precedents, we're confirming ideological far-right judges, and that wasn't unique just to Justice Kavanaugh's confirmation process. Although I must say that was the least transparent and most partisan confirmation process I've seen in 44 years. May have been others before I was here, but speaking just of the recent, the last 44 years, and it is part of a broader trend. Yesterday, for the seventh time in this Congress, and we haven't even finished the 2 years of this Congress, we had 2 circuit court nominees on the same hearing panel. That's in less than 2 years. That happened only 3 times during the entire 8 years of the Obama administration. And worse, for the first time in our committee's history, we had 2 nominees without a blue slip from a home state senator. Now we have 2 nominees rated as not qualified by the ABA. For one thing, the rating was unanimous based on several instances of ethical concerns, including candor to the court. Do we really want to put somebody on a court who comes there with an ethical stain on their record. And, I mean, there's not even a pretense that we're going to hold these judges to the same high standards we did President Obama's. We're not only the high standards we did President Obama's because there are no standards anymore. And, you know, Democrats will work with Republicans to confirm qualified mainstream judges. I've noted before, I voted for more Republican nominees to the judiciary than most Republican senators now serving. And in fact, a number of today's nominees will have Democratic support. So in a country the size of ours, we can find well-qualified Republican nominees to be judges who don't come with an ethical stain or don't come with a lack of qualification. Like the judge that was just mentioned that had to have his name withdrawn, and turned out he really didn't know even how to get into the courtroom. We can do better than that. There are excellent people, men and women out there who could be judges, who would have strong support from both Republicans and Democrats. Wouldn't it say something good about our federal judiciary if judges go on without a partisan stain, but with the strong support of both parties? That's all I have to say, Mr. Chairman. I appreciate the time.
Okay. I think Senator Hirano, you want to talk about something other than the two bills? Go ahead then, because I'll call on Senator Harris when we have the bill up.
Appreciate it, Mr. Chairman. I'm glad that there are a number of items on today's agenda that will receive bipartisan support, and I'm grateful for that. Before I say a few words about some of the nominees on the agenda today, though, I'd like to comment on the revisionist history and demonization of women that has been taking place. Can you pull your microphone down? Thank you. I'd like to comment on the revisionist history and demonization of women that has been taking place in the wake of the Kavanaugh hearings. The continued condemnation of our ranking member here and by the President is uncalled for and wrong. Senator Feinstein received a confidential letter from Dr. Christine Blasey Ford, who asked that her identity be protected and expressed a preference not to come forward. That is why the letter was not made public. It was not part of a conspiracy. It was part of the ranking member's commitment to Dr. Ford to keep her letter confidential. There have been unfounded accusations that Senator Feinstein or her staff leaked the letter. Again, this is untrue and unfair. In fact, when you look at the chain of events, you can see that the letter itself was not available to the public until it was turned over to the FBI, and the majority on the committee had access to it. And as Dr. Ford told us, she gave her account of the assault by Brett Kavanaugh to any number of friends. Many people were aware of the story and of the letter. Baseless accusations against our ranking member do not move us forward. In fact, we should be a lot more concerned about the President's ugly encouragement at his rallies of the so very tired chant of "lock her up." It is the richest of ironies that the majority leader has taken to calling those opposed to the confirmation of Brett Kavanaugh a mob, when several nights a month the President whips his supporters into a frenzy to attack his target of choice. To characterize the women who identified with Dr. Ford, who demonstrated and marched here in Washington around the country to demand the Senate not confirm a man credibly accused of sexual assault as a mob, dangerously underestimates what this confirmation process awakened. Women are tired of being dismissed and disbelieved, and if you want to be responsive to the American people, we would all be wise to listen to them with respect. Mr. Chairman, if you would like me to stay my remarks regarding the nominees to the point where we're voting on them, I can do so, or if you'd like me to just proceed because I only have a few more paragraphs to go.
I would like to go to a roll call vote if I could, and then we'll go to the bills, and I'll call on Senator Harris at that time.
Roll call vote on, sir?
Well, we'll have several roll call votes. The first one is from Jonathan Kobus.
Okay. At an appropriate time, I'd like to put some letters into the record in support of the Rhode Island nominee. I don't know if this would be a good time to move those letters into the record. One is from the then Superintendent of the Rhode Island State Police. One is from the Statewide Operations Commander of the Rhode Island Division of Sheriffs. One is from a 6-year former Attorney General of the state of Rhode Island. One is from the former Chief United States Probation Officer for the District of Rhode Island. One is from the United States Marshal for the state of Rhode Island, and one is from the Chairperson of Rhode Island Parole Board. I ask unanimous consent that those letters be added to the consideration for Judge McElroy.
Without objection, so ordered. Senator Durbin, and then we'll call the roll.
I'll be very brief, Mr. Chairman. There are 3 Illinois nominees on this roll. I will tell you, I believe this is how the process is supposed to work. All 3 have blue slips from Senator Duckworth and myself. We worked with the White House to find 3 acceptable nominees. We believe we found 3 that meet the standards that we're looking for in terms of qualifications, and it was done in a bipartisan manner. So I commend these 3 nominees to my colleagues.
The clerk will call the roll on Jonathan Kobes. Aye by proxy. Aye by proxy.
Mrs. Feinstein.
No.
Mr. Leahy.
No.
Mr. Durbin.
No.
Mr. Whitehouse.
No.
Mrs. Klobuchar.
No.
Mr. Coons.
No.
Mr. Blumenthal.
No by proxy.
Mr. Rono.
No.
Mr. Booker.
No by proxy.
Ms. Harris.
No.
Mr. Chairman.
Aye.
Mr. Chairman, the votes are 11 yeas, 10 nays.
Mr. Kobes' nomination will be reported to 4. The clerk will call the roll on Ken Bell, Western District, North Carolina.
Mr. Hatch.
Aye.
Mr. Graham.
Aye.
Mr. Cornyn. Aye. Mr. Lee. Aye. Mr. Cruz. Aye. Mr. Sass. Aye. Mr. Blake. Aye. Mr. Grayson. Aye. Mr. Phillips.
Aye by proxy.
Mr. Kennedy.
Aye by proxy.
Mrs. Feinstein.
No.
Mr. Leahy.
No.
Mr. Durbin.
No.
Mr. Whitehouse.
No.
Mrs. Klobuchar.
No.
Mr. Coons.
No by proxy. Oh, excuse me.
Mr. Blumenthal.
No by proxy.
Mr. Rono.
No.
Mr. Booker.
No by proxy.
Ms. Harris.
No.
Mr. Chairman.
Aye.
Mr. Chairman, the votes are 11 yeas, 10 nays.
Ken Bell, by that majority vote, will be reported to 4. The clerk will call the roll on Stephanie Gallagher, District of Maryland.
Mr. Hatch. Aye. Mr. Graham. Aye. Mr. Cornyn. Aye. Mr. Lee.
No.
Mr. Lee. Mr. Cruz. Aye. Mr. Sass. Aye. Mr. Blake. Aye. Mr. Grayson. Aye. Mr. Phillips.
Aye by proxy.
Mr. Kennedy.
Aye by proxy.
Mrs. Feinstein.
Aye.
Mr. Leahy.
Aye.
Mr. Durbin. Aye. Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye by proxy. No.
Mr. Rono. Mr. Booker.
Aye by proxy.
Ms. Harris.
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, the votes are 20 yeas, 1 nay.
Okay. By that overwhelming vote, Stephanie Gallagher will be reported. The clerk will call the roll on Mary McElroy for Rhode Island.
Mr. Ham. Aye. Mr. Graham. Aye. Mr. Cornyn. Aye. Mr. Lee.
No.
Mr. Cruz. Aye. Mr. Sass. Aye. Mr. Blake. Aye. Mr. Graham. Aye. Leahy.
Aye.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye by proxy.
Mr. Burnett.
Aye by proxy.
Ms. Harris. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 19 yeas, 2 nays.
By that overwhelming vote, Mary McElroy for Rhode Island will be reported to the floor. The clerk will call the roll on Carl Nichols for the District of Columbia.
Mr. Graham. Aye. Mr. Cornyn. Aye. Mr. Lee.
No.
Mr. Cruz.
Yes.
Mr. Sacks.
Aye by proxy. Aye by proxy.
No.
Mr. Leahy. Mr. Durbin. Mr. Whitehouse.
No by proxy.
Ms. Klobuchar. No. Mr. Coons. No. Mr. Blumenthal.
No by proxy.
Mr. Burnett. No. Mr. Booker.
No by proxy.
Ms. Harris. No. Mr. Chairman.
Aye.
Mr. Chairman, the votes are 11 yeas, 10 nays.
By that majority vote, Carl Nichols will be reported to the floor. The clerk will call the roll on Martha Packel, Northern District, Illinois.
Mr. Hatch. Aye. Mr. Graham. Aye. Mr. Cornyn. Mr. Lee. Aye. Mr. Cruz. Aye. Mr. Sass. Aye. Mr. Flynn. Aye. Mr. Fairhouse. Aye. Mr. Phillips.
Aye by proxy.
Mr. Kennedy.
Aye by proxy.
Mrs. Feinstein.
Aye.
Mr. Leahy.
Aye.
Mr. Durbin. Aye. Mr. Whitehouse.
Aye by proxy.
Ms. Klobuchar.
Aye.
Mr. Coons. Aye. Mr. Blumenthal.
Aye by proxy.
Ms. Burnett.
No.
Mr. Booker.
No by proxy.
Ms. Harris.
No.
Mr. Chairman.
Aye.
Mr. Chairman, the votes are 18 yeas, 3 nays.
By that vote of 18 to 3, Martha Packold, Northern District, Illinois, reported to the floor. The clerk will call the roll on Mary Rowland, Northern District, Illinois.
Mr. Hatch. Aye. Mr. Graham. Aye. Mr. Cornyn. No. Mr. Lee. No. Mr. Cruz. No. Mr. Sass.
No.
Mr. Flake. Aye. Mr. Craven. No. Mr. Phillips.
Aye by proxy.
Mr. Kennedy.
Aye by proxy.
Mrs. Feinstein.
Aye.
Mr. Leahy.
Aye.
Mr. Durbin. Mr. Whitehouse.
Aye by proxy.
Ms. Klobuchar.
Aye.
Mr. Coons.
Aye by proxy.
Mr. Blumenthal.
Aye by proxy.
Ms. Ryan.
Aye.
Mr. Booker.
Aye by proxy.
Ms. Harris.
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, the votes are 16 yeas, 5 nays.
By that majority vote, Mary Rowland will be reported to the floor. Those in favor of Stephen, the next one will be voice vote. Those in favor of Stephen Seeger, Northern District of Illinois, signify by saying aye.
Aye.
Those opposed say no. The ayes seem to have it. The ayes do have it. And Stephen Seeger, Northern District, Illinois, will be reported to the floor. We're going to hold over the nominations of John O'Connor, Northern, Eastern, and Western Districts of Oklahoma for a week. Now, Senator Hirono, if you'll let us go to the bills, and then I'll come back to you if you want to make your statement. We'll go to the Deter Act. I've offered a manager's amendment in the nature of a substitute. The amendment adds a deportability provision and clarifies which officials may determine what constitutes election interference. So I hope without objection that amendment will be adopted. Are there any other amendments? Anybody want to speak? Senator Durbin?
I'm just going to say very briefly, I was happy to work with you, Mr. Chairman. Senator Graham and I have come up with a bill which I think addresses the concern we all share about interference in our election and establishes a penalty to those who are found guilty of it. And I think it's the right way for us to approach it. I thank you for your leadership.
Senator Leahy.
Mr. Chairman, I agree with that too, and I hope we pass this out, that the leader, even though we're very close to election time, I hope we put it on the floor. I hope it pass the Senate soon, the House, when eventually they'll come back, and when they do, they also pass it and it'll be signed into law.
Since there doesn't seem to be any other amendments or speakers, those in favor of S 2785 say aye.
Aye.
Those opposed say no. The ayes appear to have it. So the bill will be reported to the floor. I now bring up S 3178. I've offered a manager's amendment in the nature of a substitute that clarifies the elements of the offense. I'd also like to be listed as a co-sponsor of this bill. Without objection, I'll be listed then. The manager's amendment is adopted without objection. I now turn to Senator Harris.
Thank you, Mr. Chairman. Could I just ask quickly to be added as a co-sponsor?
Yeah, I beg your pardon. Senator Feinstein and Senator Cornyn will be co-sponsors.
Mr. Chairman, I'd ask that I be added as
Senator Cruz, also. Senator Graham. Now wait a minute. We got Hatch, Graham, Cruz, Flake, and Cornyn, and Feinstein, and Tillis. Okay. Okay. Senator Harris.
Thank you, Mr. Chairman, and I appreciate your comments earlier about this bill. As you have noted, lynching is a dark and despicable part of our history as a country. These were acts of violence, needless and horrendous acts of violence that were motivated by racism. And we must acknowledge that, lest we repeat it. Between the end of Reconstruction in 1877 and as recently as 1950, the Equal Justice Initiative has documented 4,084 racial terror lynchings in 12 southern states in our country. From 1882 to 1986, there have been 200 attempts, as you have earlier mentioned, to get Congress to pass federal anti-lynching legislation, and every one of them failed. We are long overdue to correct course. The Justice for Victims of Lynching Act would amend the United States Code to specify that lynching, attempts to lynch, and a conspiracy to lynch are all federal crimes. I want to thank you, Mr. Chairman, the Ranking Member Feinstein, Senator Booker, and Senator Scott for their support of this bill. I'd also like to thank the NAACP, the Anti-Defamation League, and the Equal Justice Initiative for their support. With this bill, we have a chance to speak the truth about our past by acknowledging that these lynchings were crimes. These were crimes that were committed against innocent people. These are crimes that should have been prosecuted. There are victims and their families that should have received justice and did not. And today we have the ability, and I'm pleased to see such bipartisan support, to right this historical wrong. And we must also make clear our commitment to ensure that these hateful acts never happen again. I appreciate the support and thank you.
Thank you. I haven't heard of any other amendments. I hope we can go to vote on the bill now. Those in favor of S 31.
Take a roll call vote.
Yeah, I think we should.
Call the roll.
Mr. Hatch. Mr. Graham.
Aye by proxy.
Mr. Cornyn. Aye. Mr. Lee. Aye. Mr. Cruz. Aye. Mr. Sass.
Aye by proxy.
Mr. Blake. Aye. Mr. Taylor. Aye. Mr. Jones. Aye. Mr. Kennedy.
Aye by proxy.
Mrs. Feinstein.
Aye.
Mr. Lane.
Aye.
Mr. Durbin. Aye. Mr. Whitehouse.
Aye by proxy. If I can speak.
Yes, I have proxy. Thank you. Aye.
Mr. Coons.
I have proxy.
Mr. Blumenthal.
I have proxy.
Mr. Ryan.
Aye.
Mr. Booker.
I have proxy.
Mr. Harris.
Aye.
Mr. Chairman.
Aye.
Mr. Chairman, yes.
Quite appropriate that a bill like that would be voted out of this committee unanimously. The bill will report to the floor. Senator Hirano.
Thank you, Mr. Chairman. Regarding the nominees on the agenda today, 4 of them are just the products of the Republican Party's crusade to pack the federal courts with ideologically driven partisan judges. The group of nominees that we considered here today highlights how the majority party is willing to disregard the barest of standards and qualifications in its nominees. Jonathan Kobus, nominated for the 8th Circuit, received a not qualified vote from a substantial majority of the ABA's Standing Committee on the Federal Judiciary. They reported that Kobus has neither the requisite experience nor evidence of his ability to fulfill the scholarly writing required of a United States Circuit Court judge. They continued saying the Standing Committee had difficulty analyzing Mr. Kobus's professional competence because he was unable to provide sufficient writing samples of the caliber required to satisfy committee members that he was capable of doing the work of a United States Circuit Court judge. In normal times, this sort of negative evaluation would be given to the White House before they decided to nominate someone, and the person would not even be nominated. But these are not normal times. Instead of following normal procedure, the White House has nominated someone profoundly unfit to serve for a lifetime on the Circuit Court, but who will nonetheless be confirmed basically on a party line vote. I'm also concerned that Mr. Kobus's history of anti-choice activism makes it impossible for him to fairly consider cases on reproductive rights. He represented as a volunteer so-called crisis pregnancy centers, which were seeking to uphold a South Dakota law requiring doctors to inform women seeking abortion that, and I quote, the pregnant woman has an existing relationship with that unborn human being and that the relationship enjoys protection under the United States Constitution and under the laws of South Dakota, end quote. This is an unacceptable level of political bias to bring to the 8th Circuit. Anti-choice activism also appears in the records of Kenneth Bell, a nominee for the Western District of North Carolina, and Carl Nichols for the District of Columbia. Mr. Bell has taken extreme views on a topic he needs to decide on without prejudgment. But in a letter to the editor in a local paper, he criticized an article defending abortion, stating, and I quote him, either the unborn is a mass of cells worthy of no more consideration than a hangnail, or it is a child which may not be killed. There is no middle ground, end quote. Mr. Nichols defended pharmacies seeking to use religious objections to avoid dispensing emergency contraception, not a position showing any understanding of the fundamental rights guaranteed by the Constitution. Of course, it doesn't surprise me that we have more anti-choice nominees that we voted on today. It's part of the profile of a Trump nominee. Month after month, we see a parade of young conservative activists nominated to the federal courts. They are mostly a homogeneous group in many ways, not much diversity. They have been groomed by conservative political ideologues, and they want to see Roe v. Wade overturned or narrowed into oblivion. Mr. Chairman, we can do better. The federal courts deserve better, and the American people deserve better. Thank you very much.
Meeting adjourned.
Chairman, can I be recorded?
Recorded on which one?
Voting in, as I voted in proxy, but in person.
On what issue?
On the votes that have been passed.
Without objections, so ordered. The rules would provide that you can do that as long as it doesn't change the outcome.
The Judiciary Committee wrapping up its work, including marking up and approving a bill that defines lynching as a deprivation of civil rights. It makes it a federal crime. They advanced a number of nominations out of committee. The Senate itself working on judicial nominations with a series of votes set for around noon